Okay, so I think we've covered quite a lot of ground. I'd just like to focus on some questions that we've had from some firms of advisors. Well, actually, one in particular, Alex, hope you're listening. Here are your questions. I'm not going to do them all. They do go on. Right. Right. Question one: investors who've come through wraps, e.g., Transact. Yes, what way will they be treated from a legal standpoint?
Well, I suppose the point of view of a wrap is that the legal owner of the investment might not be the investor. However, even if it's held as a nominee on behalf of that investor should have the beneficial interest in that investment. So they are still the one that suffered the loss. So I wouldn't see that as an insurmountable obstacle.
That will not be a problem.
We might have to have a little look at the exact structure, the way the investment's held through the wrap, but ultimately it shouldn't prevent that investor from being entitled to take part in this exercise.
Okay. What funds remain in the ACCG and can the funds be transferred to the SPV? All funds are exhausted within ACCG at the end of this exercise, so there will be nothing left, and it's been running on fresh air for quite a while, if truth be known. Are the specimen cases simply being put forward? Oh, you'll be paid, don't worry about that. Are the specimen cases simply being put forward for the purposes of pre-action disclosure?
No. Oh, so the specimen cases?
Yes, but there'll be a knock-on effect. But yes, the specimen cases are peculiarly or particularly for the exercise of pre-action disclosure.
So could you just explain these special cases then?
Well,
as distinct from there's 100 private investors have all signed up. What's the difference?
In fact, there really doesn't have to be a difference. We could have any 2 or 3 from any of that 100. What we want to do is put before the court 2 or 3 specific examples, and the court will accept that. They won't want to hear all 100. This is how I came to invest in the funds. This is the prospectus that was shown to me, and this is what my funds are worth at the moment.
Right. Okay. I'm not going to read these all out because we've covered quite a lot of this. There is the prospect that the FSA may rule. They may step in and say, right, here's our ruling on it. Compensation's now due from Capita, blah blah blah, to all the investors, and they all get their money back. Okay. If you're into a scenario where you've made a deal with a third-party investor who's going to take 20%, 25% of any recovered compensation, what do you think, David, would be the impact of...
The first impact is, if that happens, it would depend on the investor's agreement with a third-party funder. I suspect that the third-party funder may be alive to possible regulatory compensation and may tie into a definition of recovery, not just something ordered by the courts, but something ordered by the regulators.
Yep.
So there is a risk, investors, I think I've got to say, that in those circumstances, if you recover 100% of your losses, that 20% goes to the funder. There is a risk of that.
Okay. My view on that, having tried to get anything out of the FSA, I mean anything, and bearing in mind we are now dealing with more than 18 months of private investors, not rich investors, private investors in an FSA authorised fund, unable to know and understand any timetable relating to the repayment of their investment and their rights to compensation. I can't sit here and say whether it would be 6 weeks, 6 months or 6 years before we'd hear anything from them, and they won't say. So that's part of me, my instinct is, even though there may be a risk that you get involved with a third party, and realistically, David, that's going to be in how many months' time? 4 months, 6 months' time? Yep. So it's not an immediate early risk.
No.
Okay. At least with civil proceedings, you are actually controlling what happens. You're not reliant on some quango, some third party, some ombudsman giving a ruling. Yep. You're actually pushing the ball yourself.
From the FSA to deal with the FSA, they won't say anything in the meantime. From their perspective, the way they deal with things, if they were going to order Capita to pay compensation, they would have had to have found that Capita had done something wrong. The way they deal with actions against their own authorised firms is that they don't say anything until they've reached a decision on that, which is pretty much why it's impossible for them within the current regulatory framework to say what they're doing. So they might be doing something, they might not, but you will never find out until they've gone right the way through that process and made a decision, which is very uncertain.
Would be a very long process for the FSA to make payments out. I think the litigation route will be over long before that, is my instinct.
Okay. Then there's the ombudsman route. Okay, and we know that Gareth Fatchett and Regulatory Legal are trying to go down that route. My take on that is, let's see how Gareth gets on. If he wins, yeah, and that's a route, then it's a route, and then investors would be minded to definitely go down that route and get up to 100 grand, which will cover quite a lot of them. Yeah, okay. So there are still some things that are happening outside of where we are that might have a bearing on what happens next, but nothing so substantial or substantive that we shouldn't go to the next stage.
That's my take as well. There's two decisions to make in a way. The immediate decision is, do we go to the next stage? I'd almost say yes, whatever is happening with Gareth Fatchett. At the moment, you can ride two horses.
Yep.
Now, the stage after next, you might have to think about it, and we'll see where Gareth's got to in 4 months' time.
Yes, okay. So I got a cold.
But for now, the decision in the next few weeks about whether to take it to the next stage, I mean, I suppose I would say this anyway, but I would say, hey, it does no harm. Why not? Why not have a look?
Quite.
Why not have a look at both? You can watch two films at the same time at the moment. Yeah.
Yes, okay. But if we do formalise proceedings, the Ombudsman, for instance, might turn around and say, OK, I cannot hear any case
Correct.
Related to these funds from whether you're in the SPV or not.
Correct.
Yeah, because there's civil proceedings in the background.
Yeah.
But if you only need 10 of us to take that next stage, and they're within their rights then to say that, which could mean that some of what's going on with the Ombudsman is sort of had to be put to one side anyway, because civil proceedings would take precedent.
Correct.
Yeah.
But pre-action disclosure is exactly that. That isn't civil proceedings. We can make a strong case
Sorry,
for saying
realise that.
we are trying to find out whether we want to go to proceedings.
Okay.
That shouldn't. The decision will be the FOS in the end, the Financial Ombudsman Service. But you can make a case out for saying that this is exactly that. It's pre-action. FOS might take the view or might take the excuse, because I'm sure they don't want to investigate these matters, or at the risk they don't, that they try and blur the two. We don't know, to be honest, John, at the moment.
Right, okay. Oh, Alan, is there anything else
I
ready
think
to
we've
cover
covered
in this?
pretty much everything we wanted to cover and all Alex's questions. I mean, I think what we're saying is, for the commitment that is involved to go to this next stage, yes, there is a small financial commitment on behalf of the investors. We don't think it's significant. We think it's worth it. The potential payoff is there, and you won't be querying your pitch too much with the Ombudsman if
Correct.
you decide if we decide following the pre-action disclosure exercise, assuming it's successful, that you don't want to go ahead. So, yes, you have to put a bit more money in, but the potential gains are worth it at this stage. That's what we're saying.
Yeah. David, fine?
It's exactly right. We've done it in stages to try and minimise cost. That's right, but it does mean that we've reached a stage where we need a little bit more to take it forward.
Yep.
Yeah.
Okay. And finally, we met with counsel in Bristol, John Virgo, and we took great comfort from his statement, both in his opinion at that meeting, that he felt an application for pre-action disclosure would succeed.
Yeah, we should actually divide the two, really. It's difficult for anyone really to say with any certainty at this point how the likely success of an action, because we haven't got all the information yet. We have to take it in stages, is what we've been doing. But he was very, very positive about the likelihood of success of that pre-action disclosure application if it has to be made. He thinks we should get it. Then it's a reassessment of the actual merits of the case. But looking at the one thing we do know about the moment, we think we should get that application for disclosure if we ask for it.
And just so that we get this right, but that would mean that into my world, my space, I would finally get what I've always asked for, which is knowledge of the underlying investments of these funds. Because I think when we get that, IFAs can take a look and say, well, do you know what? How on earth were we ever supposed to know that that was what they were investing in? Yes? Yeah. And if 18 months after the funds are suspended, we still don't know, yes? How would they have been able to know pre-suspension? Yes, because...
Well, there's a degree that it's not, we need this to take it to the next step, but there's some vindication involved as well if we get those documents.
Absolutely.
Yeah. The other point on that, John, is if IFAs are facing complaints from their clients about these investments, the fact that it's taken us this long, and if we do get it, the disclosure, they can turn around and say, as you said, look, how would we ever have any idea of
what
this
was going on?
when we were recommending these investments to our clients?
And they were FSA authorised funds administered by a FTSE 100 company. And if they can't run those funds properly, how are we supposed to go in and check that Capita know what they're doing?
Exactly.
That's not our job.
Correct.
No.
Okay, right. Okay, so to investors and intermediary firms, that's the one and only broadcast for racing. My thanks to Alan and to David. And next steps will be to write out to everybody in respect of it's a new compensation group and just bullet point the broad headings of what we've discussed today.
Yeah.
Thank you very much.
Thanks,
Thank you,
John.
John.
Thank you.